All right, so welcome everyone. This is the CB4 Estate Planning webinar. I want to give a special thanks to our speakers this evening, Josh Brown, CB4 First Vice Chairperson, and also a licensed real estate agent. And then we also have Ms. Shaina Jones McGrone, who is an attorney, Squire. Thank you for joining us this evening. We're really excited to have this conversation, and I will let you take it from here. Josh?
Yes. Good evening, everyone. As we know, good evening. As we know, housing is the most important issue here in Bushwick, and we as a community, education is critical to empower everyone to make informed choices, because we've seen some of the setbacks, things that's going on with our community. So tonight is about us getting education, us being able to empower ourselves, and for everyone here to know how to navigate the estate planning process, whether someone died, or whether you're looking to transfer property, or if you're just legacy planning. This is vital information that we believe is key for everyone. So at this point, I'll pass it off to our speaker for the night, lawyer Shaina Jones, and she will take the floor. Shaina?
Yes, so good evening, everyone. My name is Shaina Jones McGrone. I'm the founder and managing attorney of Artisan Law. I want to thank Community Board 4 and Josh Brown for inviting me to meet with you all and talk with you all tonight, and really to do something I love, which is talk about the law and talk about estate planning. I'm super excited to be here tonight with my folks to talk with you guys about this. So I definitely have slides prepared, information to give you, but since it's an intimate number of us tonight, why don't we take it back a little bit? I want to give you some information, but I also want to make this an opportunity really to answer your questions to the extent that I can. And if we, come to a point where the moderators really want me to pull up those slides, I'm happy to do that as well. But let me just start by giving you a little bit of information about me so that you know who you're talking to. So I've already told you my name, but I'll tell you again, it's Shaina Jones McGrone. I'm a practicing attorney licensed in the states of New York and Pennsylvania. And my firm is Artisan Law. I own my own law firm. I'm the managing attorney. And at this firm, I practice estate planning, business succession planning, as well as some business planning, which includes business law and intellectual property. So let me tell you a little bit about me and why you might want to hear from me about estate planning. So first, I'm a native Brooklynite. I'm a daughter of Brooklyn, a daughter of East New York. My family has owned our family home in East New York for over 50 years. So I come out of Brooklyn. I know the Brooklyn mentality. I love being around people in Brooklyn. And I love talking to my folks. I'm also a daughter of the South. My mother was from Georgia, so I have those Southern mannerisms. And I'm a daughter of the Caribbean. My father was from Barbados. Yeah, my father's from Barbados. So any Bajans, any folks from Christchurch, St. Michael's? All right, there we go. Okay. So, I'm also gratefully in my family, the person who got to do a lot of firsts. I'm the first person to finish college. I'm the first person to graduate from law school. I also hold a specialized law degree, so a postdoctoral law degree, and I'm the first to do that. And I'm the first law firm owner. So I became an attorney because I really wanted to use the law to make a difference for people who look like me. I've been an attorney for 14 years, and I started my career as a public defender in Philadelphia. I actually went to Temple Law School, and I started at their public defender office. And after about 4 years there, learning quite a bit, being very grateful that I was there, I still didn't feel like that I was making the impact that I wanted to make. And I found that I really wanted to work with clients to help them to build something as opposed to just being with them at the crisis point. So I made the change. I did some business litigation work for a while, and then I finally moved over to business transactional work, to intellectual property work after getting a master's of law degree in IP. And then I went on to get specific higher level training in estate planning and business succession. And I did that because in working with business owners and having a real desire to help people achieve generational wealth, I came to understand that being an entrepreneur is one amazing pathway to accumulate wealth. But if you're not taking the proper steps to preserve it and pass it along to future generations, you're losing so much of what you've worked so hard to build. So that is how I come to you today. At this point, I kind of want to ask the moderators if you just want me to start taking questions, or if you'd like me to give a little bit of, background on probate and wills and trusts before we open up.
Yeah, if you can give a background, and how many slides is the presentation that you have? Because I think it's also helpful sometimes depending on how long.
The slides? Well, it's a fair number of slides, but there's slides that move quickly. So it's about 25 or 30 slides, but they move fast. Okay. They're not this. Okay, so then I'll pull up the slideshow. All right. Just give me one moment. Investigations into events in the government industrial school. They're stopped while doing. All right. Just give me a moment to put this in slideshow mode. There we go. Okay, so what I'd like to give you all an entree into tonight are some basics about estate planning. We're going to be talking about wills and trusts. And I want to let you know that what I want you to learn tonight is about the New York probate process, why you want to avoid it, and what are some ways that you can plan for success using estate planning to do that. And also, if you stay to the end, I am a gift giver. So I've got some gift for you guys, and I hope that you're able to take advantage of them. So I've already given you background about me and background about my firm. If you have any additional questions about it, I'm happy to talk more about that. But we're going to move into the meat of the presentation. I want you to feel free to ask any questions that you like. And since there are so few of us, feel free to stop me along the way. Or if it's preferable to you, there's a Q&A box in every Zoom. Put your questions there, and I'm happy to address them. So let's talk about New York probate and why you want to avoid it. I like to start off with stories because I think stories make concepts more relational. And I'm giving you a famous story because to me, Prince was a beloved person. He was definitely beloved to me. And I think that his story shares a lot of the pitfalls that can happen to anyone, not just someone of his level of wealth. So of course you all know, Prince was the multi-talented, amazing musician that he was. And several years ago, he passed away tragically and unexpectedly. And in his wake, he really left a mess. He had a hundreds of millions of dollar estate, multiple properties, multiple types and forms of intellectual property, ongoing deals on the table. And he had no estate planning in place. He didn't even have a will. He had no children. His parents were gone. And so it was left for his siblings to essentially fight about how his assets were going to be divided. And they are still fighting. I believe it's 4 to 5 years later, maybe even 6 years later at this point. We don't know the exact value of Prince's estate, but what we do know is that I believe at this point it's about $40 million has been spent in order to try to get to the proper division of Prince's assets. And they're still moving through probate court. So we do know some of this information because since Prince had no planning in place, all of his assets, all of his heirs are made part of public record. Now, I don't know how closely you follow the news about his estate, but the saga just keeps on going. If you're familiar with Prince, you're familiar with Morris Day and the Time. And you may not know, and I actually didn't even know, though I knew that Prince formed Morris Day and the Time and he was instrumental in the band, I didn't know that he held the trademark to the band's name. That trademark was never transferred to Morris Day, never transferred to any corporation or entity owned by Morris Day or which he had any control over. And Prince's estate has now recently, as of about 2 or 3 weeks ago, told Morris Day that he can no longer use Morris Day and the Time to perform. So can you imagine decades of using this name, having built an entire legacy on it, having it being so connected to Prince and having no control over how it's used and people just telling you what can and can't be done with a name that you've essentially built, even though it was owned by someone else? So the pitfalls that you find in Prince's story is that, there's really no one heading up what's going on with his estate. There's fighting between siblings. There's an exceptional amount of money that's been spent, most of it going to attorneys. And then you have these ripple effects for people in Prince's orbit because he didn't take the time to put any planning in place. So let's talk about when you don't want to be in my office. You don't want to be in my office in the aftermath of someone passing with no planning, because in the midst of you grieving over the loss of a loved one, you're having to scramble to figure out what their assets are and how to distribute them, how they would have wanted them to be distributed. And of course, at that point, you really don't have a say. You really just have what the court's desire is for how assets are going to be distributed. So that's going to move us into New York probate. So if you don't take the opportunity to create a plan for yourself and your family, the state has a plan for you. And let me tell you how that plan works. There's a significant cost, right? That's number one. There's a cost in time. There's a cost in energy. There's a cost in emotion. But let me run you through how it functionally works. Upon the passing of a loved one that has no planning in place, they're known as being intestate, okay? And upon their death, all of their assets are frozen, all of their accounts, everything. There can be no transfer to anyone. No funds can be used to bury that person. Everything is frozen. What also happens when you pass away intestate is that all of the information about your estate and your heirs becomes part of public record. So test this if you would like. Surrogates Court is in downtown Brooklyn, and feel free to go down there to the extent that they're open right now. I believe they're having hearings on Tuesdays, but you can go and you can look in public records and you can see about the estates of individuals who have passed without wills in place. You can see who their heirs are. You can see everything that's going on in any proceeding having to do with them, and you can see their distributions. Now, I don't know about you, but to the extent that I can avoid it, I want to avoid having that many people in my business like that. All right. Now, we're going to talk about wills in a little bit more depth in a while, but I also want you to know that even if you have a will, it doesn't avoid probate. It allows you to have, of course, more control than having nothing at all, but it still doesn't avoid that public process. But let's move along with probate for someone who's intestate, or really even someone who has a will. So the court has to grant, right? An attorney is going to file a motion in order to open the person's estate. And at the opening of that person's estate, the individual who's charged with what is called marshaling your assets or gathering your assets is going to go through that process of figuring out what you own and who you owe it to. So if you pass away intestate, the person who does that is called an administrator if it's a man, or an administratrix if it's a woman. If you have a will, and of course you're still going through probate, the person is called an executor if it's a man, or an executrix if it's a woman. So they go through gathering or marshaling your assets. And the first priority is to pay off the people that you owe and to pay off any of your debts. There's a time period that is allowed for your debtors and creditors to put in a claim for money that you owe to them. Once that period has passed and they know that all debts are paid and all heirs have been notified, then there's going to be the distribution of your assets, right? And of course, you see in the interim that there might be, a sale of real estate if necessary in order to pay creditors, right? And then at the last point, you have beneficiaries being paid. So there's a couple of things that I want to see here. So first of all, if you have children who are under 18 and you pass away with no planning for them, that's going to cause a significant problem because minors, as in people under the age of 18, cannot inherit outright. So you're leaving the court to create an intestate trust for them and leaving all of the planning up to a court. You also leave up to the court, or you leave the court to administer what is actually the scheme of distribution. So your assets are not necessarily going to go to the people that you want them to in the way that you want them to. It's just going to be distributed in accordance with the statutory scheme of distributions. So of course, there's assets that will go to your spouse if you have a living spouse first. Assets will then be distributed to your children. If you have no spouse and you have no children, then the court is going to look to other heirs in your line. They're going to look to parents first, then to siblings until they can find someone. So here's what we know about the financial costs of probate. Generally, there is about 5 to 7% of the probatable estate that's eaten up in fees. Those fees can go to attorneys. They can go to the executor, executrix, or administrator, administratrix. They can go to appraisers. Of course, you may need an appraiser if you have real estate, to accountants, to court costs, to various other costs and professionals that are necessary in order to make sure that your assets are properly marshaled and are properly distributed. So that 5 to 7% isn't coming out of the estate, right? Because the estate is frozen. That 5 to 7% is coming out of the pockets of your heirs to pay. And then once all of the payments are made and all of that is addressed, then we can have reimbursements. But at that point, you already have your heirs losing money. You already have your heirs paying folks that maybe they wouldn't necessarily have had to pay if you had taken the time to plan. And 5 to 7% is a significant amount of money to lose from an estate. And the fact of the matter is that if you live in New York, generally your wealth table is going to be higher than many other places in the country. If you own property in New York, your wealth table is already higher because real estate is worth so much in the United States right now. Now you'll see on the corner of the left-hand side, there's a note about out-of-state property. If you own any assets in another state, there will be something called an ancillary proceeding in order to address probate for those assets in whatever particular state in which they lie. So if you have, real estate in New Jersey, there'll be an ancillary proceeding there. Probate in New York can also be so devastating because of the timelines. But before I get there, let me tell you what happens if you can't find, or if the court can't find someone to inherit from you. So if no one can be found to inherit from you, everything that you own, all of your assets are going to go to the New York State Department of Unclaimed Funds because no one can be found to whom they belong. This is really essentially where assets go to die, okay? So right now, there is $17 billion in assets of New Yorkers that haven't been claimed. They could be lottery winnings. They could be lawsuit judgments. Of course, they're going to be assets from estates. And these funds just sit there. They sit there if and until someone can possibly claim them, if you can get over the hurdles of this department, and they are significant, in order to prove that you are the person to whom these funds actually belong. New York has New York's Department of Unclaimed Funds has the most funds of any department of this type in the country. So let's talk about the timelines. The timelines are so significant for probate. They're so devastating, and that's another reason why you want to avoid this process. So pre-COVID, we knew that having a probate proceeding could be anywhere from about 9 months to 15 months. So you have to think about that. That's 9 to 15 months where a loved one's assets are frozen, where loved ones cannot get to access things that they need to access and move on with their lives. In COVID, as we all know, everything screeched to a halt in New York. Everything is taking longer. We're 2+ years into this pandemic and we are still not out of it. And conservatively, at this point, you should add about 6 months onto the probate process on either side. So now we're talking about timelines of 15 months to 22 or 24 months to get to the probate process. Can you imagine being tied up or having someone's assets tied up for 2 years in a process and just waiting and waiting and waiting for it to be over? That's a lot. And it's really something that's avoidable. So we've gone over the timelines with COVID. I'm going to go back to that privacy provision. You have no privacy when it comes to probate, whether you have a will or whether you die intestate. It's all up for anyone who wants to go down to surrogate's court or check out court records to see what you owe, who you owe it to, and who your heirs are. And that can be of particularly distressing if you do have minor children or if you do have special needs dependents, because it really, it allows people who are predatory to know that there is a vulnerable person that can be preyed upon. So now I want to go into what a will and what some other planning tools are. So if you have nothing else for estate planning, you need to have a will. Because at the very least, the will is going to tell the court what your wishes are about how you want your assets to be distributed. It really, at the very least, puts power in your hands about how your legacy is divided. You need to make sure that the will is properly executed with witnesses as well as notarization. And whomever are the trusted individuals in your life, of course, need to know where your will is at, so that if and when you pass away, well, I should say when, because we're all going at some point, but when you pass away, someone can go and file this will with the court and the probate proceeding can start. Okay? So a will is a primary planning document for estate planning. In addition to allowing you to tell the court and everyone else how you want your assets divided, it also allows you to do things like waive a bond. So when you have a will based probate proceedings or intestate probate proceedings, well, let me step back. When you have probate proceedings and you are intestate, the default is for there to be a bond. And a bond means that you have to put up money in order to administer a loved one's estate. So in order to become the administrator or administratrix. So either you're putting up that money yourself, because the court has to be assured that the person who is going to gather the assets and distribute them isn't going to steal from the estate. So you either have to put up that money yourself, or you have to receive the bond or receive coverage of the bond from a surety company, which subjects you to being proven creditworthy and several other hurdles that you might not want to go through. When you die without a will, you can't waive that bond provision. When you have a will, at the very least, you can do that. And if you're only going to have a will, you certainly want to waive the requirement of a bond. So you don't have to put your loved ones through those hurdles and the possibility of being disqualified from being able to address your assets if they don't have the necessary criteria to meet a bond, right? So let's talk about a trust. So you've heard a lot about probate, and you might be saying, oh my goodness, how do I get out of this thing? So one of the most amazing planning tools to use is trust-based planning. You should think of a trust like a box, and it's a box where you put your assets. And when you think about some of the most common types of trust, which is called a revocable living trust, that type of box is very flexible. It's a box where you can put assets in. It's a box where you can take assets out during the course of your lifetime, right? So when you create an RLT, or a revocable living trust, or revocable living trust, however you'd like to pronounce it, during the course of your lifetime, you perform 3 roles. You're the grantor, which means you're the person who puts assets in the box. That may also be, you may also hear the term settlor or trustor, but it's all a person who puts assets in the box. You play the role of the trustee, which is the person who stewards the assets, right? Who has control over the distribution of the assets. And you also play the role of the beneficiary. So during the course of your lifetime, you're the person that the trust is supposed to benefit when we're talking about a revocable living trust. You can do whatever you want with your assets during the course of your life, and it is at the end of your life that the box shuts and your wishes come into play. Trusts are very cool for many reasons. First and foremost, they avoid probate, okay? Trusts are private documents that do not have to go through the probate process. No one is going down to surrogate's court and is going to be able to see your trust. It just is not done. It's a private document. They have to be executed appropriately and according to New York state law, but they are valid and binding documents that determine how your assets are supposed to be distributed. When your assets are distributed through a trust, it's called trust administration. So generally, trust administration takes about 3 to 6 months. And the cost of trust administration is often less than 1%, sometimes up to 2%, okay? So significantly lower in cost, significantly less time, and significantly more privacy and control. There are some amazing things that you can do with trusts that go to tax planning, that go to the creation of generational wealth, and go to the protection of individuals in your family. So let's talk about some of the people that might want to think about trust-based planning. I know you may have heard, if you've done any digging or investigation into estate planning at all, that trusts are really are often seen as assets that are really for the wealthy, or what's considered the wealthy. That's really not the case. Trust-based planning is for most people in the country, and I'm going to run down some criteria of individuals, or some criteria for you to think about in order to determine whether or not trust-based planning may be for you. So first, if you have assets over $30,000, you're going to want to think about trust-based planning, and here's why. $30,000 in New York is the threshold for a small estate, and a significantly expedited probate process. Most people are going to have assets over $30,000. If you own a home, if you worked for a period of time and have any sort of retirement planning, anything like that. So if you have assets over that amount, you're probably going to want to think about how trust planning can work for you. So that's first. If you own a home and or any other type of real estate, you're going to want to think about trust planning. One, you want to find a way, if you have debts that need to be paid upon your passing, in order to steward your real estate so that it doesn't have to be sold in order to pay off those debts. Trust planning is also going to allow you, if you have multiple people who you want to have ownership in the home, to be able to appropriately steward how that's going to happen. Or if you do have multiple people in your life and you don't want them all to own the home, ways to steward that so that it doesn't cause confusion within the family. You don't have multiple people owning a property and not being able to get along. So if you own a home or you own real estate, you want to think about it for the ability to properly address to whom the home is going to go to have the possibility of avoiding the home being sold in order to pay for your debts, and to pay for the cost of time that probate would take. And you are also going to want to think about it if you have a home, because home ownership, of course, is one of the main ways to create generational wealth. And to the extent that you can protect and that steward that property for generations, trust-based planning is going to be one of the most viable ways in order to do that. So people with minor children are going to want to think about trust-based planning because, as I said to you when we talked about probate, minors cannot inherit outright. So let me give you a little bit more in-depth information about what happens if you die with no planning and you have a minor child. Whatever the amount is that's supposed to go to that child, the court is going to create something called an intestate trust for that child. They're going to find a trustee. They're going to determine who the trustee is to steward those assets. That's going to take time and money to steward that. They may not pick the person that you want. And that trustee is going to steward the assets for that child until they turn 18. And then they're going to dump whatever money is left in that trust into the minor's bank account outright. So think about it, if you have several hundred thousands of dollars in your estate, and think about how much money you could have received at 18 without going crazy, right? Without just losing your mind. And so when you don't have any planning in place, and you allow that to happen to a minor, you set them up to be preyed upon. You set them up to really blow through their money and blow through their legacy because they don't have any help to guide them, to allow them to learn in order how to steward money for themselves. So people with minor children are going to want to think about trust planning for those reasons. Let's talk a little bit more about minors. So when you die without any planning, and you have minor children, you subject them to the possibility of going into state custody because there has to be a guardian for a child at all times. And if you haven't put any planning into place, the court is going to take some time to figure out who that guardian should be. We do at my firm something called a kids protection plan to make sure that no minor ever has to have that experience if their parents or their guardian doesn't make it home. But even if you don't work with me, you need to make sure that you create documents that determine who are going to be the short-term and long-term guardians for your children if something ever happens to you. There needs to be a plan in place for your children to make sure that they're taken care of. And you certainly want to make sure that whomever is going to be taking care of them has a medical power of attorney for that child so that it's also clear that that person has the ability to talk with doctors, get the medical treatment, know what's going on with their treatment, and help steward them in that way also. If you have special needs dependents, trust planning is going to be something you want to think about as well. So there's a couple of reasons. First of all, if you have special needs dependents, they may be receiving Medicare or other types of state benefits. And you want to make sure that the assets that go to them don't disturb the ability for them to receive those benefits. So there's certain types of planning that has to be put in place for special needs dependents. Oftentimes when you're dealing with special needs dependents, we're not talking about a revocable living trust. We're talking about different types of trust planning. But all the same, you still want a estate planning device that is going to allow those assets to be properly used for the health, welfare, and well-being of those dependents over the course of their lifetime. If you have problem children and challenged dependents, so this is what that means. That means if you have a child that may have some form of addiction, do you have a child or a dependent that has an alcohol or a drug addiction, a gambling problem? I recently had a client who had this. They have an adult child, right? It's not a minor. They have an adult child, and they want to make sure that that adult child doesn't blow through their inheritance, or really, because they have an alcoholism problem, getting a large amount of money distributed to them in one fell swoop, they want to make sure that that child essentially doesn't drink themselves to death because they have the opportunity. So if you have problem children, children who have addictions, children who have other issues, trust-based planning is a way to make sure that money is stewarded for them so that they don't blow the money on their addictions and they don't harm themselves with the assets that come from your estate. If you're in a second marriage or a blended family, and I know about those, you may want to think about trust planning. So, I mean, second marriages are great. Sometimes you get the best one the second go around, right? But you may have children, or your spouse may have children from that first marriage. And people can get a little antsy when they wonder where their money is going to go. Children may get a little antsy when they wonder if they're going to get anything from their parent upon their passing. And what does that create? That really creates disharmony. It creates distrust. It creates people waiting around for, if it's a second spouse, the spouse to die to see whether or not they're going to get anything. And that's not what we want, right? We want harmonious relationships in families. We want people to enjoy the time that they have with each other, not wait for them to die. And I've seen it, I've seen it in my own family with my husband. His parents were in a second marriage. His half sister complained about everything that my husband's mother did. Complained about everything because she assumed she wasn't going to get anything. She was always on the woman's back. And these people had trust planning in place, So imagine if you've got nothing, right? But was on their back constantly because she, didn't know what was going to happen. And she assumed that she was going to be left out. One of the ways to avoid that sort of situation is to think about giving a distribution to children from your first marriage upon the passing of that parent, right? Because it lets those children know that they are thought about, that they were planned for. And it really oftentimes puts people at ease, and it continues the harmony in a family. Medicaid planning. So let me give you a couple of statistics. I should have given one of these to you at first, at the beginning. Well, actually, I think I'll give it to you at the end now. But let's talk about Medicaid planning. So the statistic from the AARP is that 80% of people over the age of 80 are going to need long-term care at some point in their life. Long-term care being a nursing home or assisted living or in-home care from an aide. Now, that doesn't mean that once they have it, they're always going to need it. That just means they may need it at some point. And so when you need long-term care, it's going to come from one of three pots. It's either going to come from your pocket, it's going to come from long-term care insurance if you happen to have it, which many people don't, or it's going to come from Medicaid, okay? So let's talk about what the cost of long-term care is. In New York, the cost of nursing home facilities on a monthly basis, on average, is anywhere between $15,000 to $20,000. For in-home care and in-home aid, it's anywhere between $10,000 to $15,000 per month. Who can afford that? Most people don't have long-term care insurance and don't even know about it. So long-term care insurance is an insurance product that you can pay for over the course of your lifetime to pay out for you to pay for nursing home, in-home, or assisted living care. But here are some of the pitfalls with it. First of all, long-term care can be very difficult to get because you got to imagine and understand that's a significant risk for an insurance company. So they make it difficult to get. You've got to be really healthy to get it. The premiums can be very high. And even with the high premiums, the payout may not be that much. So I recently talked to a prospective client that had long-term care insurance for, he had long-term care insurance for his mom. The long-term care insurance was only the benefit was only $4,000 a month. They're in New York, so they're still short by at least $6,000 if we're talking about in-home care, and probably more than that, and 15 if we're talking about nursing home care. So even the long-term care insurance may not give you what you need. So let's talk about Medicaid. So ICP Medicaid, which is the part of Medicaid that addresses planning for long-term care, is what many people need and have to qualify for in order to get that assistance that they need later on in their life. But the threshold for assets is very low. You essentially have to be destitute in order to qualify for Medicaid. Currently, for one person, you can only have about $18,000 in assets, right? Income. And for a married couple, about $24,000 in assets. So what are you going to do, right? Because most people have more than that. So what are you going to do? The first option, which really no one wants, is for you to spend down all of your assets until you're destitute in order to get Medicaid. That's a horrible option. So first of all, you spent all of your money, you've got no reserves left, and you've spent away your family legacy so that you can be taken care of in your later life, right? That's where trust planning comes in. One of the most amazing tools for Medicaid planning is called a Medicaid Asset Protection Trust. Now, that's not the only tool for Medicaid, right? There's a series of tools that you can use in order to qualify for Medicaid. And I know all of this because I specialize in Medicaid and special needs planning. But there are a series of tools that you can use in order to qualify for Medicaid. But you do actually have to plan for them in advance. You do have to be aware of the options and make appropriate decisions. But what a Medicaid Asset Protection Trust allows you to do is by giving up some control over your assets, really a lot of control, it's not just some, but you give up control over those assets to the extent that the government will say, these assets don't even belong to you anymore. We won't count them for your income or your assets, and therefore you can become eligible, right? That's one tool, it's not the only one, but it's a very powerful, it's an amazing tool. But the point is that it's a trust-based estate planning tool and something that you want to think about and plan for. Now, I know a lot of people think that you only really want to start thinking about Medicaid planning when you become older. That's really not the way to think about it. You know, everyone is going to get old. Hopefully, right? You're going to get old. Hopefully, you're going to get old in excellent health. But you don't know, right? You want to hope for the best, but you want to plan for the worst. And so even my point is that even younger people want to start thinking about what their options are, you know, and they want to start thinking about what the trajectory is going to be. And that's one of the most amazing things about estate planning is that it's not a one and done thing. It really is a journey. It's a journey that changes and should morph with you over the course of your life as you grow and change, as your family grows and changes, as your assets grow and change, and as the law changes. All right. So Medicaid planning, those who are thinking about Medicaid planning want to think about trust planning. Self-employed and business owners, you want to think about trust planning as well. And of course, you want to think about business succession planning, which goes hand in hand with estate planning. And you want to think about trust planning because you want to make sure that your business is not just up in the air and held in limbo upon your passing. You also want to make sure that the people that you want to benefit from your business benefit from your business, okay? So other necessary documents. So let me talk to you about when estate planning is really complete. There's really two sides. With estate planning, you have to make sure that your assets are properly stewarded and properly distributed. So whether we're talking about will-based planning, if that is what works for you, or some form of trust-based planning. And we have to make sure that if for some reason you are incapacitated during the course of your life, if you can't make financial or healthcare decisions for you, that you have trustworthy agents, fiduciaries, who can make those decisions for you and make those best decisions for you. So the other half of planning is powers of attorney. financial powers of attorney, and advanced healthcare directives, which consists of 3 documents in New York. Your healthcare proxy, which indicates who has the ability to talk with your doctors and make medical decisions for you. If you're incapacitated, your living will, which addresses what your wishes are if you are in a terminal state. What do you want to have happen? And your HIPAA release, which is going to allow those agents to get your medical documents, see them, see your medical records, and have access to them. You want people in place to make these decisions for you, who are trustworthy, who you feel can make those decisions for you. And you want to put these decisions down on paper because you don't want to leave your family in a quandary of trying to figure out what you wanted and being in turmoil because they feel that they have to make a decision for you that they don't want to make and they don't know what to do. It's a horrible place to be in. So estate planning is what happens when you pass away, to distribute your assets, and what may happen to you or who's going to address you if you're incapacitated. To me, that's complete estate planning. To me, that's how my office and my firm works. All right, so I'm just going to talk with you about a couple other cool things that my firm does because I think that they're really cool. In my opinion, it's not just what you give to people, intangible assets that's important. It's your story, your love, and your wisdom. So we do something cool called a family legacy interview for clients, where there's a questionnaire or various questionnaires you can choose from, and we interview together, and you get to record your thoughts for your family. I consider it a bit of a living testament. It comes with your estate planning. All right. We also do some other fun stuff. I know that for people, it can be very difficult to talk with their family members about their planning. They may not want to talk with them at all. And I really do try to facilitate that process because, intergenerational knowledge about estate planning is the way to carry it forward. And it's the way to make sure that assets don't slip through the cracks. Okay. All right. My firm also serves people digitally. We've done that before COVID. We do that through COVID. And, we do that because it's convenient for everybody and it's exceptionally flexible. All right. I do have an office that I meet people at. But I find that people love this process and it really does work for estate planning because it's super transactional. Okay. So we're basically at the end of the presentation. I have some, giveaways that I want to give to you, and I'm going to talk about those. But I really want you to, take in this information and really think about what you want your legacy to be, how you really want to move forward with your life. Estate planning is one of the most amazing tools to create a trajectory for you because you have to figure out what you've got and then you can make a plan to get to where you want to be. I love it. I think it is so amazing. I think it is super amazing for Black and Brown people. And I'm happy to answer any questions that you have.
So, Shaina, we do have something in the chat. This is going back to the first document that you mentioned as fiduciary. The second was power of attorney, and the third was living will. They were just missing the first one.
So I talked about 2 types of powers of attorney. I talked about financial powers of attorney, which the people who are your agents there are going to address your financial matters if you're incapacitated. And I also talked about your advanced healthcare directives, which are 3 documents in New York that consist of your healthcare proxy, your living will, and your HIPAA authorization and release. So you'll have fiduciaries in all of those documents, and they may be the same people.
Got it. Thank you in the chat.
Okay. You're welcome.
All right. So any other questions? I know we've had some folks jump on since we started. Josh, did you have something?
Yes. I want to say phenomenal content, Shaina. Thank you so much. So much clarity. Shaina, could you just speak on the whole surety bond? Are you saying as if I can't get a surety bond as if a relative died, I won't be able to do anything with the estate? Because that seems very almost discriminatory in that I'm subject to a credit check. Could you just elaborate further?
Absolutely. So the point of the bond process is to make sure that the person who is administering your estate, and I'm using administering in the large process, right? In the larger term, is not going to steal from the estate. So I don't know the origins of it completely, right? Oftentimes when you look in the origins of things, you find out things about them. But I'm going to say on the outset, it's really a way to protect heirs, right? You want to make sure that the person is not going to steal from the estate. And so they require you to put something up in order to make sure that you're not going to steal from the estate, right? It's money. Okay. And so, yes, if the next in line, or if the person who would normally be chosen to administer your estate either doesn't have the funds to put up, or can't be, or a surety company will not provide the funds for them, absolutely, you can be bounced from being the administrator. Or if you have a will and haven't waived the bond provision, the executor for your heirs, or for your decedent's estate, for your loved one's estate. So it may be discriminatory in the sense that, yes, if you don't have good credit and you don't have any funds, it's going to be a problem, right? But in the law, there's often a way to get around the thing. And the thing is to do the planning and to waive the bond provision.
Thank you.
Yeah.
And another question from the chat, Hadia would like to know, how can we contact you?
Oh, absolutely. So I'm going to tell you my contact information. I'm also going to drop it all in the chat for you so that everyone has it and you can grab a screen share of it if you want to. And then I want to take other questions, but I definitely want to tell you about some things I got for you guys. So I'm just dropping that here, and I'm happy to take any other questions while I'm dropping that in the chat.
Perfect. So I actually have two scenarios that I would like to share. These are actually experiences from folks that I've spoken to in the neighborhood, both when I was in the city council and then when I was at the community board. We had a family member come to the office one day. Their mother had recently passed. The mother was the owner of the home and the person whose assets were in question, correct? And this individual had a brother and a sister that were older, that it was an understanding that they were the ones that were going to be having these conversations. Although due to her mental health status, she was left out of those conversations because she was one of the vulnerable family members. She didn't know what was going to happen next, and she relied heavily on her siblings to keep her included, although she was pretty sure, just due to their family circumstances, that it wasn't going to be something that she necessarily was going to know everything about, because she was closer to the mother and she wasn't really sure how things were going to look. To date, we've seen a home, this is on Halsey Street, in the neighborhood, right across from Irving Square Park. That was probably once a lovely family home that's been completely abandoned. It's turned into a squatter house. There have been fires there, and all of this because, other family members may have moved on. But it's just an example of how, and I think it leads back to this: if there's no clear cut, process or procedure, or where does that property go next? That's what could happen, right? And we end up where assets are in limbo. And who knows if those family members, right, that were responsible ever came back and did anything. And a very similar, and I have a question that I want to bring when I finish all of this up, but there's one more example on Broadway. There's a family that was living in a home, very similar story. The mother had passed and, they all stayed within the residence. However, they did not pay any of the taxes. They didn't pay the mortgage. No one paid attention to it, despite the fact that a majority of the people living in the home were working, making money. It wasn't until they realized the property was going to go into a short sale that they were forced to try to do something. But at that point, it was already too late. And then individuals from that household, one out of several, contacted me and said, I'm looking for an apartment, but I can't find anything that's affordable. And I'm starting to realize that we probably should have kept this house, even though everyone didn't care. So these are real stories. These are assets that, have been in families, but are being lost because there's a gap. And so I guess my question for both of those, You know, in the first instance, this is clearly a vulnerable family member that may or may not understand how to navigate the process. You know, what is the best step for them to take, right, in order to have a better understanding of their rights? And I guess for the second process, what is the easiest way for someone, you know, sometimes the fear is, you know, we don't know where to start, so we just keep putting it off. But how can we, right, as a community board, simplify that, you know, and encouraging people? It's not just about, oh, go figure this out on your own, but what's the first step that people can take when it comes to figuring out how to start this process?
Yeah, so let me answer that question. I think the first thing that has to happen is that there really has to be a shift in mentality about estate planning, you know, because estate planning can be very difficult for people to address because it forces you to look at your own mortality. And in addition to forcing you to look at your own mortality, it forces you to look at where your assets are. And oftentimes our assets are not what we want or think they should be. So it brings up these feelings. And so I think there's two shifts. I think first, look at estate planning as a labor of love for those who are going to be here when you're not. Because you're not going to have to deal with the mess, they are. And as in both of those examples that you mentioned, the loved ones are going down. They're having a worsening of their situation because their decedents, their loved ones, didn't address the situation. I think the other shift that needs to happen is that, particularly for our communities, we have to really believe and know that what we have is some real for real stuff. Everybody wants our stuff. Look at how our neighborhoods are going. They don't even call Bed-Stuy anymore. I don't know what they call Bushwick. You know what I mean? And they're running up in East New York too. You know what I mean? These houses that we live in, I don't know how much my parents bought this house for, but these houses are now 700, 800, 900 million plus, 2 million plus, 3 million, 4 million plus houses. I don't care what the thing looks like on the inside or the outside. We have stuff. But even if that's not your situation, it doesn't matter whether you've got a penny or 2 million, it's still your stuff. And you still need to respect your stuff enough to take the time to address it and make sure that it does what it's supposed to do for the people who are there after you. So I think it has to do with a shift in mentality. First, I also think that, you know, really one of the main things is education. I certainly don't expect, and no one should expect lay people who are not attorneys to have the understanding of estate planning that a professional does, that I do. But what the basics that you have to understand is I want to be responsible and take the lead in determining where my stuff goes when I go. That's really the standpoint that you need to start from. And there are many ways in order to figure that out. So if you go from the standpoint of I want to be responsible of figuring out where my stuff has to go, that's going to lead you to a lot of places. And then there are many different ways to get to the outcomes that you want. We didn't even talk about, and there's really not time here to talk about so many of the advanced and really cool things that you can do with trust planning. Now, as for that vulnerable individual, that particular example that you gave, so the hard thing is at this point is, well, first I would ask a couple of questions. First, has her mom's assets, or have her mom's assets even gone through the probate process? Or had the assets just languished? Because someone actually has to start probate. It doesn't just start miraculously. Someone has to actually do it. And until that is actually done, the assets, if you're in the probate process, but until whatever proceeding that's going to happen, if you're intestate, or if you have a will and you're in probate, or whether you're doing trust administration, the assets don't actually transfer until you start the process. So people's things, you know, can be in the name of the decedent for time immemorial if you don't actually take care of the thing. I know of people who have just lived in the parents' estate or parents' home and paid the taxes and paid the mortgage. Okay, that's not the way to do it. People do it though, but you have to start the process. So I think question one is, has anything actually ever happened? Did the process start? And I don't know what, dependent upon what her level of need is, I think is a question for determining what other services and or advocates she may need in order to help her move her through. Because I don't know what her special need is, and I don't know where her level of cognition and ability is.
Thank you. Hadia?
Yeah.
Hi. Yeah, I just wanted to add on to what Shaina already mentioned. Of course, she would be much, much, much more well-versed in this than I am because she's a practicing attorney. But I do have some experience with this sector of law, and that the issue of, leaving a home to relatives in your name when you are deceased, that is a big, big problem within minority communities. And I think the term that they use to characterize that is called like a tangled title. So, your children or your grandchildren or any other relatives will inherit your property or another asset, but because it's in your name and you're now deceased, they can't do anything with it. It's just like dead property, basically. If they need any type of repairs done on the property and the city is offering any type of services or emergency funds to help like seniors or something like that get repairs, your relative wouldn't qualify to get that if the deed is in their name. And they can't sell the property, especially if there's other relatives, because everybody has a portion of ownership to the property. And as time goes on, families can get pretty big, especially with minorities. You know what I mean? You talk about it could get up to 30, 40, 50, 60 descendants who have a say-so in that property. So I think this was a very, very informative webinar, and I hope we can continue to share some of this information throughout the community here in Bushwick. It's a crisis that I do know has been impacting us for a very, very long time. Starting out in the South with Black Americans, we've lost thousands of acres of land because of heirs property, which is similar to the tangled title situation. And now up north, we're going through the same issues because we're not correctly transferring our wealth. And I think we need to be more informed about understanding that we do have wealth. I think people believe because we're impoverished or because we're minorities, you think, I don't have anything to leave my kids, but you do have something, even if it's just your home. That's something, and that means something. Just like Shaina said, everybody is investing in our neighborhoods. They want to be here. This is prime time property. This is the good land. They don't have to worry about floods and other, natural disasters. So they want to be here in our homes. So we need to start taking more pride into that. And I hope we can continue forums as such. That's all I wanted to say.
Thank you, Hadia. Let me just say one thing. That's an interesting term. I had not heard the term tangled title, but I don't want people to get confused. It's not a tangled title. You don't have title if the stuff has not been properly transferred. So you may be an heir. You may be entitled to the asset once the proper transfer has occurred, but you don't own it if the transfer has not taken place. I see there's two questions in here in the chat that have been sitting here. So I'm gonna take those I'm gonna take one of them, and then I see that Joanna has her hand raised. So the question here is, what is the difference between I guess that's the two types of trust. This is from Tanisha. So there are many types of trusts, and there are reasons to elect to do various trusts or various combinations of trusts. But on the whole, the two splits are, is it revocable or is it irrevocable? Is it revocable, meaning it can be changed during the course of your lifetime, or revocable if you choose to say it that way? Is it irrevocable or irrevocable, meaning it cannot be changed once you make the transfer, right? And so there are various scenarios that fit whether or not a revocable trust is appropriate or an irrevocable trust is appropriate, or whether or not you need a combination of the two different types of trusts. So that's the big difference. The flexibility and the ability you have over your assets, and the ability to change the trust once the trust has been created and funded. Let me also say this about trust. So it doesn't just stop when you actually create the trust. You have to actually fund the trust, right? That's the legal term, meaning you got to get your stuff into the box, which means assets have to change title. So, you know, if you get trust documents, I'm always going to suggest that you plan with an attorney, and an attorney that really is an estate planner. But if you decide to get a trust and you don't actually put your assets into the trust, you don't actually retitle your assets, you basically have some hollow paper. You got a paperweight. So you got to take the process all the way through. You have to change the deed. You have to change the bank accounts. You have to change the life insurance, all of those things. You must fund your trust in order for it to have teeth. Joanna?
Thank you.
You're welcome.
It almost goes back to Celeste's question about how you start. And I even see the question going back farther than that when it comes to families. I know you're not a family counselor, but that's the problem. How do you even get the conversation started where that parent, many of the older people, the only thing they know is a will. And that's what they think, that you're going to see their will when they die, and that's it. Then, they're not trusting. They don't even want you to know if the taxes haven't been paid. They don't want you to know these things. They hide it. And it seems to me that a place to start where a lot of older people trust is the churches. That's, they go to the church, and to hear this information in a church where the pastor's talking to them saying, listen, you've got this wealth, you need to, and the senior citizen centers, those people, that information, places that they trust and occupy. It's difficult. I know it was so difficult for me to try to talk to my mother, and I never got information. It was as though, she just knew, well, when I die, you're going to get everything. Mom, did you write a will? Where is it? She just did not want to share. And that's the old-fashioned way of thinking. And now there's lots of problems, and I know I'm not the only one going through this. I talk to friends, it's the same story over and over again. And yes, just as you say, there are people out here every day offering you, a box full of cash, a suitcase full of cash. We are losing, and it's hurtful and it's harmful to me. So what do you say? How do you even get that conversation started without making that person feel, oh, I'm trying to push you in the grave. I just want what you got. It's hurtful.
Well, I'm going to say, first of all, I acknowledge and hear exactly where you're coming from. And I'm going to say a couple of things. So first of all, estate planning is actually everyone's decision, right? And as much as you may want someone to do something, they actually still may not do it, even if they know it's going to cause problems for you. So I think you have to reckon with the fact that that actually may be a consequence. But the other thing that I would suggest is, can you find a trusted professional? Can you find a trusted estate planning attorney to have that conversation with you? Because if you know, like I know, your parents may not listen to a word you say, but if you bring in someone else.
Oh, Absolutely.
It may
It
be
happens
all
all the time.
good. So my
And the
point
sadness
is that
about it, and I hate to say it about in our communities, they'll listen to that white person rather than the Black professional. I don't know why that is, but it's true. I'm sure you've run across it.
well, here's what I'm going to say to that. What I'm going to say to that is I'm going to think the best about our people. And I'm going to think that when they have amazing Black professionals to work with, and then when they know that they are there and they can get the information, they're going to work with their people, right? But Black, white, or indifferent, I still want you to get the planning. Love it if you did it with me, but get the planning, right? So you may want to find a trusted estate planning professional to talk with your loved one and give them some information. Also understand that it may take more than one conversation. And also, if you put the conversation in the framework of mom, dad, you're really hurting me by not taking care of this thing, that may hit differently than do you have this will? Have you done X, Y, and Z? If you put it in the framework that you're really hurting me in the family by not doing this, because it really can hurt you, then they really may consider doing some things differently than if you say it a different way. The other thing is that, older generations can be very fixed, right? And so maybe it can't start with your parents. Maybe it has to start with you and your kids. And maybe you have to be the person to break the chain and move it on along differently in the generations coming behind you. So those are my thoughts. I will also say that I this year am really on a mission. I do agree with you. Churches and senior centers are oftentimes the ways to get in contact with our folks. So I'm reaching out to churches and senior centers now. I'm happy to come and do a talk and do an educational session at a church or a senior center to get the information out there, because it is about the education. The statistic that I did not give you at the beginning that I meant to give you is that the current statistic is that over 70% of Black Americans don't even have a will. Isn't that crazy? That's crazy. Over 70% don't even have a will. And speaking of a will, listen, any planning is going to be better than no planning. So you very well may want your parents to get a trust or do X, Y, and Z, but a will is going to be better than nothing. So if that's all you can get, then at least get that. I see a question in the chat that asked about New York State's law about divorce beneficiaries.
That's me.
Well, I mean, oh, okay, Carlotta. Well, it's not really New York State's law. It's about, well, okay, let me step back. If you are actually completely divorced, unless you plan for your divorced spouse, then they should not inherit. But the question is, what have you done with your life insurance policies or other policies that have beneficiary designation? Well, if you didn't take the time to update your beneficiary designation and you left your divorced spouse on your policy, then they're going to get your policy. So you have to take the time when you have life changes to update what's going on with your estate. With that being said, let me say a couple of things about beneficiary designated assets.
You could put me, right? You could put me.
She sure could.
I
And
need
you know what I mean?
I need to follow up with that. I am supposed to be the beneficiary. He didn't update his beneficiary, and he didn't leave a will. And they refused to give me the.
And they don't have to. And they don't have to. They don't have to.
Oh,
No.
okay.
I mean, we can talk privately. Maybe there's something else going on, but
Yeah.
that's an unfortunate situation. And it happens far more often than we think about. People forget. They don't think about it. But there's no obligation on the other party that received, that actually was the named beneficiary, to pass to you simply because the relationship has changed. All right.
Okay.
Also, beneficiary designated assets. So, for example, life insurance, right? That's one of the key ones. Let me also say this about life insurance, and then I want to get to the stuff that I want to give you guys. Life insurance is so pivotal for everyone for the protection of your family and your assets, But it's also pivotal because life insurance is the way to create an immediate estate, right? So let's say, for example, you take out $1 million life insurance policy. Over the course of your life, you may actually not be worth $1 million, but upon your passing, when that policy comes due, you've left $1 million in assets to your heirs. It's the way to create an immediate estate. Life insurance is an amazing and powerful tool. So if you do not have some, get some. There are various types of insurance, right? With the general breakdowns being, is it a term policy? Meaning after a period of years, the policy is done, it's no longer in effect. So if you haven't passed away during the course of that term, whether it's 5, 10, 15, 20, 30 years, the policy doesn't pay out. Or is it whole? And there are various whole life products where it is a product that will pay out over the course of your lifetime whenever you die up to a certain age, right? I think it's at 99, 100 and something like that. I don't remember what the age is, and it can vary by insurance carrier. These are policies that whole life policies do gain cash value. So you can oftentimes borrow against those policies for various things. Life insurance is very important. The earlier you can get it, where you lock in those low premiums, the better it is to get it. Okay, so I'm happy to take questions for the last couple of minutes, but I really just want to tell you about the gifts that I have for y'all. So it is super important in this day and age to plan for what's going to happen with your digital assets, what's going to happen with your emails, your social media accounts, your digital logins, right? What are you going to do? How are people going to be able to get access to those accounts in order to actually address your estate properly? So if you put your email in the chat, I'm happy to give away to you my digital asset primer sheet. And it's for you to think about ways in order to address your assets. All right, so that's for everyone. This next one is really a campaign that I've been running for the past week, because I really want people to plan. So I'm running a campaign called 15 by the 15th. Let me back up for a second. So some of the cool things that we do at my firm, I already told you some of those, but one of the other things that I do that I think is very awesome is that, we plan generally on a flat fee basis for people. So I never want you to be confused about what it is, the value of what you're receiving. I want you to understand what you're paying for and be really clear, no hidden costs. So we plan on a flat fee basis. And in conjunction with doing that, I'm running this campaign called 15 by the 15th. So for the first 15 people, and I've already had some signups, tomorrow's the 15th, but first 15 people who, we get in contact with each other, or you get in contact with me, and you schedule your planning session. In my office, we call it a life and legacy planning session, and we end up engaging, I'm going to take $1,000 off of the price. So if you want to talk with me about that, you can either say it in the chat, or I'm going to drop the bit.ly link to sign up for it. 15 by the 15th. All right, so that's the link for it. And of course, you have my contact information above if you want to think about it. If you decide that you don't want to do 15 by the 15th at any point in time, that you really want to go along this estate planning journey, I'm happy to talk with you about it. I'm going to grab those emails for folks in order to get that digital asset checklist out to you. Oh, Alonzo asked, what is my estate planning fee? So my fees range, right? It ranges depending upon what you do. So I can talk to you about ranges. I can talk to you about estate-based planning. Well, let me say this. I'm not going to talk with you about the ranges simply because that actually requires a real discussion that we can't have in these 5 minutes. What I will say to you is that the planning is comprehensive, to include both what happens to your assets upon distribution, what happens to you or who is supposed to steward you if you're incapacitated. It includes us really having a relationship, right? Like, because you can pay anyone for documents, right? I'm not in the business of selling you documents. I'm in the business of building a relationship in order to make sure your family is taken care of. Um, and also making sure that you're connected with other trusted professionals that are going to help you along your journey, because you may not only need to talk with me, you may need an insurance agent or a financial planner or an accountant, right? You may need a lot of people. And we also do some other cool things at my office. So I'm happy to have that offline conversation with you, Alonzo, if you'd like to talk about it. And I'm happy to take any other additional questions.
So I just want to add, in particular for the board's office, so we know that you're giving this presentation this evening, and this has been wonderful. One thing that we're not able to do is refer, individuals to one private business. So
Absolutely.
I guess my question is how can, community members find, just in general, someone that is a trusted professional to do this type of work? Is there a general space that we can send them to be able to do their own research that has references, anything like that?
Google.
I laugh because if I tell like 50% of the people I work with to Google it, they'd be like, why am I talking to you then? And I'd be like, but I would just Google it for you. Like,
yeah. So, I mean, here's the deal, right? The community board is right. They're not recommending me. I'm just telling you what I can do for you. But you have to make your decision about who is really going to work for you. We may not mesh. You may need someone else. You may want to figure out who I am. So you want to go to Google and you want to research people. You want to see what their reviews say. You want to see, what their website looks like. You want to see what the vibe is. You want to check out if they have information that they're already giving, right? To educate the community. And then you want to have a conversation with them to see if they fit, because there's going to be people all along the spectrum. My solution doesn't work for everyone. It works for a lot of people, but it doesn't work for everyone. There are people who find that, though I do not recommend this, that they want to just get their documents from online. There are many reasons why online documents are not the way to go. They're not tailored to you. They're form documents because that's what they are, forms. They're meant for any and everyone. You may not execute them properly. You may not do many other things properly, but for someone who doesn't have the funds, maybe that's the best that they can do. You do what you can. But to the extent that you can work with an actual estate planning professional, and that's the other point, you want to actually work with an attorney who is actually an estate planning professional. You don't want to work with an attorney who is just doing this in their spare time, right? Or just doing this because that's the next, that's who's coming in the door. The fields of law that I work in are the fields of law that I am specialized in. And even in that specialization, I have even tamped down. I told you my business is estate planning, business planning, business law, and IP. I really am focusing only on the estate planning and letting other members of my office really tamp down into the other areas, because you need to dive deep in order to do a good job for people. So,
all right.
Indeed.
So, go ahead, Josh.
Oh no, so I just want to say the quality of information presented was very good. I thank Shaina for being open, transparent, honest, and I'll pass it back to you before we wrap up, as we're being mindful of time. But I want to say thank you, and I was educated even as a real estate professional myself.
Absolutely. And I want to echo Josh's words. We want to thank you both for making this possible, and everyone who joined us this evening. I see Ms. Bennett. Okay, your hand went up briefly. Did you have something, or? Okay, so we'll go ahead and we'll wrap up. And
I was looking for the applause emoji. That's what I was looking for.
Oh,
I had the hand
yes.
raised. That's the one I was looking for. Please excuse me.
There we go. And I know our chairperson, Mr. Camacho, was able to join us, so I'll let him close with some remarks.
I want to thank you, and I want to thank you, Josh, and I want to thank you. It was I thought old people wouldn't learn tricks, but we learned, it's something, an eye opener that we need to make sure we let our people know, because a lot of times, believe me, it happens. Someone goes like that, and before you know it, you can't find a policy. You don't know if they put you on there. You don't know. And mind you, you have people that were born in a a 1919 or 1916, 1920, and all they had was $1,000, and they had a guy that was there for 40 years and he died. Believe me, so we got to make sure that we educate ourselves and make sure and it was great. And I want to thank you. It was real good, Josh. Thank you. Thank you.
Thank
All right.
you.
So that wraps up this evening. We will follow up with everyone. If there are any questions, you can always reach us at the board's office. And that's it. Good night, everyone.
Good night, people.
Good night.
Night,
Thank you.
everyone.